Thank you very much, Amanda, and members of the study group for inviting me to talk with you today about a project that I've worked on with two colleagues who teach in Canada. It's about litigation interest and risk assessment, and I know that you are very motivated to learn about dispute resolution, that there aren't necessarily the kind of resources in Brazil that we have in the United States and in many other countries. So I'm going to be happy to share what I can with you, and happy to answer your questions as we go along. I've got a PowerPoint which I'm going to start to share. So we're going to walk through that together, and we're going to start from the beginning. All right, so see here. Here's a picture of the cover of the book, and you can see the subtitle is Help Your Clients Make Good Litigation Decisions. The book is a practical guide with lots of checklists and appendixes. It combines research on risk assessment and early dispute resolution. My two co-authors, Michaela Keat and Heather Haven, have done a lot of research about risk assessment and applying it in the litigation context. And I've done a lot of work on early dispute resolution, and we combined this in the book. And we also wrote this as a practical guide for practitioners. So it's fairly concise and not very dense. It's relatively easy to read. Much of it's directed to advocates, to people representing clients, but it also includes material specifically for mediators. And if you're interested in getting a copy of the book, you can order it. You can see that the URL for that is tinyurl.com/YBC50U68. We'll provide a copy of this PowerPoint to distribute, and you can click on the link. You can get this as an electronic book, and so you don't have to worry about shipping. And if you want to order it, you can get a 25% discount by using the discount code 25 LIRA. I don't think there's a space in between the 25 and the LIRA, LIRRA for the code. So anyway, and of course, this may be more than you know, as much as you need, but if you're interested in learning more about it, you can order the book afterwards. So what are we going to talk about today? I'm going to talk about this three-part structure of LIRA, and the process for helping clients make better decisions, and the potential to take advantage of these techniques in an online environment. Of course, one of the things that's happened since the pandemic, people aren't meeting together face-to-face very much, and lawyers and clients and mediators and judges are needing to work online, and there are some variations that you may be doing based on that. And so you can apply these techniques in an online environment, and I'll talk about that a little bit towards the end. Feel free to ask questions as we go along. If you want to type questions in the chat, then Amanda will read them to me at some point, and certainly feel free to just speak up, and I'm happy to interact with you and talk with you. This presentation is based on experience in the United States and Canada. Obviously, the ideas and techniques need to be adapted to the realities in Brazil and other countries. I confess I don't know very much, hardly anything about the realities in Brazil, so you're going to need to consider what adjustments would need to be made to your situation, and certainly as we go along, if you want to talk about that, you can. I know in talking with Amanda and Pedro last week, I know that you have a much higher trial rate than we do in the United States. United States, very few cases actually go to trial, maybe less than 10% in some of our federal courts. It's about 1% of cases that lawsuits actually go to trial. I understand that in Brazil, it's a much, much higher rate of cases going to trial, and that may affect a lot of things. So well, you'll have to consider what differences there might be. So what are the goals of this litigation interest and risk assessment process? And the basic goal is to improve party decision making. This is a fundamental professional ethical obligation of lawyers and mediators. That's what lawyers are required to do, at least under American and Canadian ethical obligations. And I'm guessing that's probably true for lawyers around the world, that your job is to help clients make decisions. And although lawyers take a lot of actions on behalf of clients and make some decisions themselves, ultimately, the most important decisions are decisions that the clients need to make, and that the lawyers are responsible for providing candid information, providing information that would be relevant to the clients, and helping them make decisions, particularly the decision about whether to settle or to go to trial. Mediators also, under our ethical codes, have a responsibility to help make decisions, and that's really the goal of mediation, is to help the parties decide what they want to do and whether they want to reach a settlement. So the most fundamental goal is to help parties make decisions. Part of this is also to improve results for the parties in the first instance, for courts, and for society. And in the United States, there's a lot of research that suggests that people make what researchers call decision errors in going to trial after rejecting a good settlement offer. So let me give an example. If you're representing a plaintiff and you get an offer before trial that the defendant is willing to pay you $100,000 or $100,000 in your currency, and then you go to trial and you get only $50,000, this is a very bad result for several reasons. One is your client, the plaintiff, is getting $50,000 less than what the defendant offered, and your client, the plaintiff, has to spend more time and money going through the process to go to trial, and then incur what we call these intangible costs of the process, of the time and delay and stress. So it's a very bad result. And the research in the United States shows that in over 3/4 of the cases, one side or the other makes a decision where they get a worse result in trial than they do from the last side's settlement offer. So that's something we want to avoid. Obviously, if parties can settle and neither one is going to get a worse result at trial, you're saving the parties all this money, you're saving the courts, especially in a country like Brazil where the courts have so many cases. If you can reduce the number of cases in court, that's a good thing for the courts and for society by reducing the waste. And part of what this does is it saves, reduces the tangible and intangible costs of litigation. So the idea is to help people make smart decisions about whether to go to trial and whether to settle. Again, in the United States, most cases settle anyway. Part of the idea is to help people make smarter decisions and to do it sooner. The sooner you can make those decisions to settle, the more you can save in terms of the tangible and intangible costs of litigation. So as I said, our goal is to improve decision-making and avoid having parties make bad decisions. So why do parties make bad decisions? A lot of reasons. One is that people make cognitive and motivational errors. And maybe you're familiar with the research about what's called behavioral economics, about these cognitive biases that people have. And there are a whole lot of them, and the book goes into a number of them, and even that's a small number. I'll just mention a few of them. One of them is called anchoring. So this is a very common one. For example, if someone's representing a plaintiff, and let's say you're representing a plaintiff, and you're asking, you file a complaint and you ask for $1 million. And you know that you're not going to get $1 million if you go to trial or in settlement, but this is your opening position. Well, you can explain that to the plaintiff, but the plaintiff may nonetheless have that number in her mind and keep on wanting to go to trial because she has heard you say that you're asking for $1 million, and she has these fantasies that she's going to go to trial and win $1 million. So this anchoring by setting these extreme values at the outset can really affect people's decisions. Self-serving bias is another common one. We all tend to think more favorably of ourselves and to have negative assumptions about the other. Confirmation bias will look at information, and it will highlight and believe the things that support our beliefs and discount the things that undermine our beliefs. Hindsight bias, so each side may look at a situation and say, oh, they should have known, whereas, you know, people have 20/20 hindsight. You look at things differently after the fact. In the moment, it's hard to know, but afterwards, people assume that they should have known what they couldn't have necessarily known in advance. Reactive devaluation is an important one. So when you have two sides that are in a conflict with each other, each side tends to distrust the other one. And so if one side said the sky is blue, they may disbelieve it because it's coming from the other side. So if you heard it from a mediator or from a judge or from some neutral person, they would believe it, but because it comes from the other side, they tend to doubt it, and that's this reactive devaluation. Another cause of bad decisions is what's called sunk cost bias. When people have been in litigation for a long time, they've invested a lot of time and money in it, and they feel, well, gosh, I've gone this far, I have to keep on going. If I don't, then I'll have wasted all this money. Well, it's an understandable feeling, but it just is not a good way to make decisions. Whatever money and time you've invested up until now, there's no getting it back. It's a sunk cost, and all you can do is try and reduce your costs going forward in the future, but it's a very common one. And another bias is partisan role bias. So if you folks become lawyers, and some of you may be lawyers now, and you represent a client, you are likely to take on the biases of your client. So plaintiffs' attorneys tend to see things the way their clients do, and defense attorneys see the things the way their clients do. And so it affects people's judgments. And so that's one of the reasons why people make, or these are lots of reasons why people make some of the bad decisions and may end up going to trial when that's foolish, as I mentioned. Another problem in the United States, and I'm guessing this is probably true in Brazil, maybe even more so, is the dynamics of the lawyer-client relationship producing what we call a conspiracy of optimism and prison of fear. Conspiracy of optimism is when the lawyer and the client both have an interest in presenting and viewing things as optimistically as possible. The client may come into the lawyer and say, not want to share information that may make them look foolish or may undermine their case. And so what the client may emphasize the positive things and may not mention the negative things. On the lawyer's side, the lawyer may want to first have the client decide to hire them, and second, convince the client that they are there for them and they're going to be a vigorous advocate, so that they're going to err on the side of being more optimistic. So what that means is that both the lawyer and the client have a bias, have a reason to try and be more optimistic than the facts may suggest. And related to that is this idea of a prison of fear. What that's about is that lawyers and parties may be afraid to approach the other side and, well, to suggest that there's any weakness, uncertainty, risk of losing. They're afraid that if they do that, that it will suggest weakness to the other side. Lawyers may be afraid that they're going to lose their client's confidence. And so if they feel that they need to take on a tough position and suggest that they're very, very confident, and they end up believing this optimistic view. So there's this, all of these factors encourage over optimism and not necessarily realistic assessment of a case. And then a third set of causes for bad decisions are reluctance of lawyers to communicate clearly and specifically about litigation risks. One of the problems with litigation is it's inherently uncertain, it's risky. And there are just, again, in the United States, and I'm guessing it's probably true in Brazil as well, so many things that you just can't anticipate. You don't know who the judge is going to be. You don't know how the clients or the witnesses are going to come off when they are testifying. There are all sorts of, you don't know if some witnesses may not appear. You just don't know what's going to happen. And so lawyers are very wary about being very specific and confident. And so they'll want to be vague about what will happen, or sometimes in the United States, they'll be overly specific. Sometimes they'll write these opinion letters that are very detailed and it will identify all these different possible risks that the clients won't be able to understand and interpret. So the lawyers are often very afraid of talking specifically about litigation risks. And what that means is they may tell the clients, you know, I think you have a good chance of winning, but that's very, very vague. And clients may not be able to understand and interpret what that means. So if you use the process that I'll be describing, this is something that lawyers in the United States often address many of the elements, but not as systematically as we describe. And what this does is it explicitly focuses on intangible costs, which are often overlooked or undervalued. This is really, really, really important. And my guess is, and you can tell me as we go along, that this may be one factor, one reason why the trial rate in Brazil is so high, is that people are afraid and they're not valuing their intangible costs as much as they should. And if they did, they would be more likely to be willing to settle. And we'll talk about what those intangible costs are. It provides a logical sequence to enhance party decision-making and enables practitioners to adapt their process to the philosophies and needs of particular parties. Different lawyers have different ways of handling cases, and different parties have different needs. And what this technique, this process that we're talking about is very flexible, and each lawyer can adapt it for their own approach and the needs of particular clients. So it can help clients understand their interests in litigation risks, identify legal and factual uncertainties and possible outcomes to estimate their BATNAs and develop bottom lines, and explicitly consider tangible and intangible costs. Now, you may or may not know, and actually I should have said BATNA values, and you may know what a BATNA is, but in case you don't, a BATNA is a best alternative to a negotiated agreement. And I see that I messed up here because people are confused often. A BATNA is a course of action. So if you're in litigation, your course of action, your alternative to a settlement, to negotiation, is going to trial. Now, people often use the term BATNA referring to the value, the expected outcome of going to trial. So what you're really going to be doing is you're going to be estimating the value of going to trial, the best alternative to a negotiated agreement, and then to develop bottom lines, which actually are much more significant than BATNA values. The BATNA value is one part of the bottom line, as I'll describe. A bottom line is really something that is necessary for developing a good negotiation strategy. And what this will do is, by doing all the things I've just described, it will help you help your clients develop effective litigation, negotiation, and mediation strategies. So there are three elements of, oh gosh, I've screwed up again. The expected value of the court outcome, it should say the BATNA value, not the BATNA. So that's the first element, is what you expect would happen if you would go to court. The second one are the tangible costs of continuing to litigate. The third one are the intangible costs of continuing to litigate. And we talk about this in the context of litigation. It can and should be used before lawsuits are filed. The earlier you have this analysis, this assessment, this conversation with your client, the better they're able to make decisions and the more they may be able to save in terms of the tangible and intangible costs of litigating. Many cases in the United States, and I'm guessing many in Brazil as well, do not, people settle without ever filing a lawsuit. I mean, you don't have to file a lawsuit in order to negotiate. And certainly if you can reach a good settlement before a lawsuit is filed, there are many advantages. You save some money. It reduces some of the adversarial dynamics. So one of the things that I encourage you to do as you are in practice is to, if you have a client that's in a dispute, is to discuss at the outset whether it makes sense to negotiate even before filing a lawsuit. It generally focuses on monetary disputes, but it also can focus on non-monetary issues. And it focuses on future costs, not past sunk costs. So you avoid that sunk cost bias that I talked about. So the first element has to do with the expected value of what would happen if you went to court. And litigation is a very valuable process in the United States. I suspect it probably has similar benefits in Brazil. It can provide substantial benefits to parties in society. If you're dealing with a party on the other side that's very unreasonable, that it's really important that you can't negotiate with them. You can't rely on them to either reach an agreement or carry through an agreement. It provides a mechanism for structuring a process for exchanging information and managing the dispute resolution process. It provides opportunities for vindication. There are lots of benefits that litigation can provide to parties and to society. Obviously, again, in the United States, litigation is something that provides information about the nature of disputes, and sometimes, particularly when you're dealing with large entities that are important for people to know about. So litigation is important, but it's also inherently risky, and parties, just by definition, can get unfavorable court decisions. And I think one reason why in the United States the trial rate is so low is that people are aware of the risk and they're afraid of taking the risks. And it's important to understand for parties to develop realistic expectations about the court outcomes because these are major factors in negotiation and mediation. So the second element are the tangible costs. And I mean, this is obvious. Litigation imposes tangible costs, including the legal fees for represented parties, legal expenses for discovery and for experts and so on. And this can be quite substantial and can make a big difference to parties. One of the things, again, lawyers often have a hard time making realistic estimates about what the costs are going to be because it's just unpredictable. A lot depends on how much the parties are going to fight with each other. And it's just very hard to know. The third one are these intangible costs. And being in litigation imposes many intangible costs on parties, such as stress, which can cause physical and psychological harm. One of the things that my co-authors have done research about, and the book goes into a lot of detail about, is how stressful being a party in litigation can be and how it actually can cause or aggravate physical and psychological problems that people may have. It's just extremely nerve-wracking for most people. So just being in litigation, just having to answer questions in discovery, and I'm assuming you must have some process like discovery where people are required to exchange information. You may have to give a deposition and be questioned by the other side. It's extremely stressful. People often feel the process is very unfair. They feel disrespected. They feel victimized. And this is both plaintiffs and defendants. In family cases, this may be true for both spouses and for kids. It's just an extremely unpleasant process. People feel stuck in the dispute. They're not getting on with life. They can't do other things. It obviously can damage relationships. It can harm people's reputations, and it can impair their ability to do other things. They're investing time and money in litigation that they could spend on other productive activities or just relaxing, taking time off, and businesses could be investing their time and money in other profitable activities. So just being in litigation imposes all of these costs, and it's really unfortunate that in the United States, and I'm guessing in Brazil, lawyers and mediators often don't pay much of any attention to the intangible costs, which is something that this LIRA model talks about. And they're important because they're very important to parties, sometimes more important than the court outcomes. A lot of times lawyers assume that it's really all just about what would happen if you went to court. They assume that the parties want to win, that they want to get the most favorable financial outcome that they can, and often that's true, but often these intangible costs, these problems that I just described, just being in litigation, are extremely important to parties, sometimes more important than the court outcomes. And people often ignore or undervalue them, which these costs, which reflect parties' interests. And you can help parties identify and value intangible costs, for example, by asking how much it would be worth to avoid the delay, risk, stress, and so on of going to trial. So if you're representing a plaintiff and you think that you could get $100,000 at trial, you might ask the client, okay, if the trial is going to be in 6 months, how much is it worth to you to avoid the delay, the risk, the stress of going to trial? Would it be worth it to you to accept only $80,000 instead of $100,000, so that you will essentially be buying the avoidance of the stress and the risk, the uncertainty? So part of what this is about is helping clients figure this out. And what that can do is can make settlement more possible if each side values the intangible costs, so it reduces the expectation for a monetary outcome. So let me just stop there for a second and see if people have any questions or comments that they want to make. And you can either type it into the chat, or if you want to speak up.
Hi, John. Good evening. Can you hear me?
Yeah, I can.
My name is Alvaro. I work with negotiating settlements for companies, and you were talking about the costs of litigation. I was going to ask you a question because my feeling here in Brazil is that the access to the judicial system is very easy. You don't have to pay a lot of money. There are the costs and fees to have a litigation is not a big problem for people here. So with having intangible costs and having those costs being the more important for the parties, how do you feel that you can bring that to the other party to show them that, hey, look, it can be easy for you to start litigation, but it's not the best option?
Sure. Well, thanks for the question. And I guess part of it is having a conversation. There are two things. One is having a conversation with your own client, and then also having a conversation with the other side. And the book goes into some detail, and I'll talk more as we go along about the things that you can do in terms of talking with your clients about what it is that's most important to them, how the litigation has been so far, what their expectations are, if they have particular concerns, if they think that the litigation would affect, for example, their relationship or their reputation. You can ask a whole series of questions about that, and I'll go into about that in more detail. Part of what you can do with the other side is they may not share information about their clients' intangible costs, but this is something that your client may be able to help you understand the perspective of the other side. And as time goes on, in a case, you may learn about what the other side's interests are and be able to say, look, if we settle, this will be a real value to your client because they're really stressed about this case, or they really need to get this case resolved soon because they have some business deal that they need to take care of, and this is going to get in the way of that. So part of it is being a good lawyer. Being a good lawyer is asking questions and learning information that's relevant. And really what this is about is asking about these factors that lawyers often don't consider. I want to go back a second to the first thing you talked about, which was about the tangible costs. And I gather that what you're referring to was the court filing fees to get into court. And in the United States, they are a relatively small proportion of the tangible costs. The much greater portion of the tangible costs are the lawyer's fees, which can be very, very expensive. And I don't know what the situation is in Brazil, but mostly we're looking at the lawyer's fees. If you have to hire experts, if you have to do depositions, all of these things can add up to a lot of out-of-pocket money that the parties have to pay. So it's not so much the court filing fee, it's really more the fees that go to the lawyers and experts and for depositions and things like that. So in Brazil, let me ask you, are those tangible costs significant for the lawyers' fees and for experts?
A common practice here for lawyers is to only receive the money when the other party wins, if their client wins. So you can start a judicial process with no cost at all, like just contacting a lawyer that would accept this kind of contract and having them file. Because here on our judicial system, they look more about how much do you earn than the cost itself. And if you earn a certain amount, you don't have to pay for the judicial fees.
So
Yes.
it sounds like the court fees. Now, what you're describing in terms of, it sounds similar to what we have in the United States with what we call contingency fees. And this is for plaintiffs typically in personal injury cases where, for example, if they're in an automobile accident, the plaintiff would, the plaintiff's lawyer takes a percentage, for example, about a third of any recovery in settlement or trial. The defendant doesn't have that opportunity because they're going to be paying out. So there's not money that they're going to be receiving. And then in many cases, the plaintiffs don't have an opportunity to have a contingency fee. And for example, in all sorts of cases, for example, in family cases, it's not like there's a recovery as such, and lawyers don't get a proportion. So what you're talking about is, in the United States anyway, is true in only certain cases for certain parties. Is that similar in Brazil, or is it for example, if you're representing a defendant, do they not have to pay your fees out of pocket?
Yeah. Can I say one thing?
Please.
Just getting what Alvaro said, that is really important about the judicial process here in Brazil. We have like we call juizado especial, which is like a small court for small amount lawsuits, until 40,000 reals, which now it's not worth anything, but it's kind of $80,000. So. Mm-hmm. And to get inside to this court, you don't need to pay anything. And if you lose, you don't need to pay anything to the other side. But as you said about the defense, for example, of course, you can have the contractual fee, and then the success fee about the litigation process. But the point is about Brazilian culture, which is people, let me say lawyers, have received a lot of money, amount of money, not solving problems, but having a lot of judicial process, you know, like every month, like the company pays one fixed, I don't know, 300 hours. I don't know, maybe, I don't know, they have 100 cases, 200 cases. And for us, it's really easy to get inside the judicial system. As Álvaro said, for example, Brazil has almost 80 million process going on, you know, almost all people in Brazil are litigating right now because we have 200 million people living over here. So the point is you can get money of course, a control fee, but people are still thinking that getting solve the problem really quickly won't be good for the lawyer, you know, about money. Oh, it's worth for me to maintain this client for months, years, and not solve the problem. And this is kind of a fear for Brazilian lawyers to act like collaborative, or I don't know, maybe as LIRA, I don't know how to say.
Yeah.
Way, you know, this is something about the culture is really strong, and to go to judicial power is too easy. You can maybe even spend nothing if you lose. So, okay, let's go to the judicial power, or maybe we prefer to go first to the judicial system and then try to make a settlement with the other part, you know. It's the Brazilian culture, let's say, making.
So there are a couple things. I mean, really what we're talking about are the differences in both the tangible and intangible costs and the way people value them. So just in terms of the tangible costs and the lawyer's fees, so are you suggesting that basically the lawyers are getting a flat fee, so that, you know, they just get a fixed amount regardless of how much time they put in? Or do they get more money if they're working more? Again, putting aside the question of the people who are getting a proportion of the settlement, but other than those, how are the lawyers paid?
With contractual fees, before, maybe, I don't know, you came against me and I'm going to a lawyer to have a defend me against the action that you proposed. Maybe the lawyer will have like a fee. Oh, you pay some amount to defend me, and if he has succeed in the end, he can get another amount. And I don't know how this works in United States, but here, as Álvaro said, we have like, for example, if you won the action, the lawsuit against me, okay, I don't know, $100,000. The judge will arbitrate it. I think you can say like that. 10% for the lawyer that win the lawsuit, or maybe 20 until 20% of the lawsuit value, you know. So you receive for maybe a contract fee in the beginning, a success fee, and a judicial success fee the other part had to pay to you.
So what about if you reach a settlement, do the lawyers get a success fee for that, or is it not at all?
Kind of. That's the point. Lawyers don't see, like, maybe Álvaro can say better than me about that because he works with negotiation settlement, but maybe sometimes lawyer doesn't think like you are thinking right now, you know. Okay, I don't have this possibility to solve the problem and win. Of course they have, okay, I can have a settlement and receive I don't know, 30%, 20% of the value, but it's not common, you know, people solve the problem like that.
So it sounds like basically there's not an incentive for lawyers, that their own incentive is to go to trial, that they're not going to get some additional compensation if they settle. Is that right in general?
Sometimes, yes. Generally, yes. But Alvaro, if you wanna, please finish.
The fees, they can be negotiated between the parties. It's not something determined. Like when you reach a settlement, you can say, oh, so you pay 50%, I pay 50%, or you pay 70%, I pay 30%. It depends on the case. And considering what the parties decided when they reached the agreement, then the judge can just settle the case, and that becomes what the parties agreed upon.
Mhm. I mean, one of the things that, if I understand, I'm not sure I fully do, but part of the problem may be that the lawyers don't have an incentive to settle, that their incentive is to try the case. And actually, I wrote another book called Lawyering with Planned Early Negotiation. And part of what that's talking about is creating incentives for agreements between lawyers and clients, for the lawyers to have incentives to settle. In the United States, where lawyers are typically paid on an hourly basis, they have an incentive to keep on litigating. I guess it sounds as if you don't have, for example, hourly fees, but if I'm understanding right, that lawyers don't get paid more if they do more work, but they get paid more if they go to court and win. And so that's what their incentive is. Am I summarizing that correctly? Okay. And then the other challenge has to do with, in terms of the parties' intangible costs, um, you know, in the United States, most people value, or a lot of people value their time and don't want to have their disputes hung up in court for a long time. I guess in the culture, and maybe you were referring to this earlier, people just expect that if they have a dispute, they're going to go to court and it's going to take a long time, and they just don't think that there's an alternative, or that they think this is the right way to do it. But for whatever cultural reason, they think that this is the way they have to resolve a dispute, and they don't see that there's really a good alternative. Is that right? I see you're shaking your head.
Yeah, sometimes, yes, sure. Yes.
So
most part of the time.
yeah, and so, in terms of working with this and working with your own client, is to talk with them about whether they value some of these things, such as resolving a dispute early. Now, if they think that that's an inappropriate way, it's a dishonorable way to resolve a dispute, you're going to have a hard time. And then you're also going to have a hard time, even if they want to resolve the dispute early without a trial, if the other side isn't willing to do it. So that's a real challenge. And I think that may be the reason why your trial rate is so high. Sounds like that may be the case.
Yeah, and one thing, like getting out, you said, like here, our mentality, mindset, Brazilian mindset, I could say that is the universities, like we are prepared to fight. Anytime during our preparation to be a lawyer here, we have meetings like that, that's the point. You came out for 5 years in a system that makes you go to the judicial power, the system. So many times, lawyer doesn't know to charge a fee if he makes like a settlement or something like that. Of course, we have huge law firms, big lawyers, and of course we have international, everything here in Brazil. But I'm saying, because we have, I think, more than 1 million lawyers in Brazil. But I'm not talking in the small part. I'm talking the whole Brazilian lawyers, which are not the biggest law firms here in São Paulo. So that's the point.
Okay. Anything else? Do we have any other questions or comments before I move along? Okay. So this is a challenge for you. And a lot of these techniques aren't going to work, and to the extent that they're going to work, it's going to be in selected cases and trying to figure out if particular clients would be interested. So what you need to do, you need to use good legal skills of asking questions and listening carefully. One of the things, at least in the United States, and I wouldn't be surprised if this is true in Brazil and other countries, lawyers generally are not very good at listening. We train people to talk, but not to listen. And listening is really important to understand what's important to your client, because the goal is to achieve your client's interest, not necessarily to win. You were talking about the culture of law schools and that you're trained to fight to win. And that's true in the United States as well. And yet, part of our culture is to recognize that maybe it's because of the risk, but that you can maybe win by settling. And part of the challenge is people think of settling as losing, you're compromising. And if you can frame it to your clients that what you're doing is you're getting them something, you're getting a resolution earlier, you're getting something where there's less risk. So in some ways, this is focusing on the intangible interests, and different clients have different interests. Some of them are concerned about stress, others aren't. Some are concerned about risk, others aren't. So part of it is listening carefully to find out what's important to your client, and then also trying to figure out what's important to the other side. Figure out what the dispute is really about jointly with the clients, and don't assume that the dispute is about the correct interpretation of the facts or law. It may be, but it may be about other sources of conflict. At least in the United States, we train our law students to assume that what the dispute is about the law. And they're really not focused so much on these other interests, and they assume that the clients just want to win when they go to court. And of course, clients do want to win, but there may be other things that are going on. And so what are some of these other sources of conflict? Well, there are a ton of them. Personality conflicts. People get into disputes because they just can't stand each other. They may have had a long-standing relationship and something comes up and they make a dispute out of it. There may be a lot at stake, and that may be prompting them to want to have a dispute because they're afraid that they either think they can gain a lot or that they're at risk of losing a lot. Sometimes there's conflict because the lawyers are inexperienced and they don't know what they're doing. Parties are afraid, and lawyers are afraid of looking weak, and so they're going to take a tough posture. The parties don't know or trust each other. Parties don't know their case yet. Poor communication, sometimes between the lawyers and the clients and between the lawyers themselves. Sometimes the parties are concerned about setting precedent, particularly if you have businesses and they have repeat a large volume of cases over and over again. They don't want people to perceive them as having, they're going to be too willing to settle. Sometimes the lawyers want to fight. They want to perform for clients. They want to increase fees. Again, the fees situation may be different in Brazil given the way the lawyers are paid, but often, this may go to the culture of lawyering that you were talking about, that you're trained to fight and to show the clients that you're fighting for them. Oh, and one other source of conflict are unrealistic expectations about the trial outcome. Each side tends to be biased about having an expectation that they're going to win if they go to trial. If you ask both sides what percentage probability they think of winning, they may, if you add them together, it may add up well over 100%. So each side may say, well, I've got an 80% chance of winning. Well, that would be 160%. Well, that can't be right. So people often have these unrealistic expectations that I was talking about. So part of what your job as a lawyer is to figure out what the problem is. Are any of these or other things that are going on? And obviously, if the problem is the unrealistic expectations about the trial outcome, you can talk about that. But if there are these other issues, you may be able to help your client, particularly if a lawsuit hasn't been filed, to try and focus on the sources of conflict and resolve the conflict. So basically, I talk about lawyers as being conflict diagnosticians. Your job is to figure out what's going on. So you can ask your client, what's most important to you in this case? And why haven't the parties settled so far? Now, again, in the United States, often what will happen is, people will have a problem and they will try and negotiate with each other. And many times they'll resolve it and they never go see a lawyer, they never file a lawsuit. When they do go to a lawyer, it's often because they've tried to settle and they haven't been able to, or they just don't even bother trying to settle because they don't trust the other side. So asking the clients, particularly at the outset, why they haven't settled so far is a good way to understand what's going on, what the problem is, what the conflict is. And again, if you can understand what the conflict is, you may be able to figure out how to solve the conflict. As I mentioned, parties generally want a favorable financial result, although they vary in what they define as favorable or acceptable. Some people have much higher or lower expectations than others. And so part of what you need to do is figure out what your client's expectations are. And they may want other things, these intangible things that we've talked about, which may be as or more important than the financial outcome. And some of the other goals include being treated with respect, maintaining good relationships, developing favorable precedent, getting an apology, having future employment or recommendation in an employment situation. There are a lot of different things that parties want. In the United States, courts generally only can award money. They can't award an apology. They can't say, Alvaro, you apologize to Jose. The courts don't do that. They just say, you pay him this amount of money. But that may not be what the parties want. They may want being treated with respect or an apology. And so trying to figure out what it is your clients want is a really important thing to do. And then try and understand the other side. And so you can ask your client what they think the other side's perspectives and goals are. Now, often they're going to give you a biased perspective about that, but you can ask them to be as realistic as possible and say, well, if you were on the other side, honestly, realistically, what would they say? And then you can ask if you think that if your client thinks that any of their perspectives or goals are justified, and you can follow up by asking if this assessment affects their assessment of the likely court outcome. In other words, if the other side has some merit on their side, maybe your client will have a less favorable, less optimistic assessment of what would happen if they went to court. And then part of, if you're thinking about negotiation, what you want to do is trying to figure out what's going to move the other side. What would persuade the other side to change their assessment? That may be their assessment about what would happen if they went to court, or maybe their assessment of the risks, maybe their assessment of the intangible costs that they would incur if they continue in litigation. So what you want to do is use your client to gain information about the other side to help you develop good strategy. Another good set of things you can do is ask the client how the case has affected them so far. This can be a good indirect way of finding out their interests. Generally, they will complain, at least in the United States. Usually, not many people enjoy the litigation process. Even a lot of lawyers don't enjoy the litigation process. In the United States, it can be very stressful, even for lawyers. And so you can find out from clients, what their expectations are, and what the problems are. And settling provides an opportunity for them to stop hitting their head against the wall because it feels so good when they stop. So what you want to do is figure out what it is that's important to them and what the problems are so that you can help them solve the problems. So how do you discuss intangible costs? We were talking about that earlier. There are many ways of doing that. So you can ask. So for example, you can, if the client has told you that the relationships were important to them, you can say, you said that relationships were important to you. How would going to trial affect your relationships or your reputation or your feeling of being stressed out or whatever it is that they've told you? You can coach them. You can say, you know, based on my experience, when I see people late in litigation, they often say it's taken a toll on them. Or you can delegate. You can tell them, please discuss this with your spouse or an advisor or people in your law, in your business, how going to trial may affect you. And you can also tell them going to trial is likely to hurt your reputation and keep you from doing the things you want to do. So there are varieties of ways you can have this conversation with your clients, starting with asking and then coaching and delegating and telling. At least in the United States, lawyers are sometimes, and surprisingly, cautious about telling clients about what's likely to happen. They're sometimes afraid that the client will react poorly to that. But if you ask and you coach and you, for example, this coaching part over here, if you talk about what you've seen with other parties, that can be a helpful thing without telling them what they need to do. You can say, gosh, you know, this is really, a lot of my clients really have a hard time with the litigation. And then talking about the tangible costs of litigation, and again, this, you need to base this on the way that the tangible costs are incurred in Brazil, how much they've spent so far, and estimate how much they're likely to spend if they go to trial. You wouldn't have exact figures, round numbers would be fine. Again, you need to adapt this to your situation. And then assess the likely trial outcome. And we encourage people to do this after asking the clients about their interests. Excuse me for a second. Okay, so in the United States, as I mentioned, one side gets a worse result than the other, than in a trial than in settlement. And I gather you're not sure whether that's true in Brazil. Is that right? Or do you have a sense of, is that a common thing in Brazil, that one side is going to get a worse result than in trial?
I don't think we have any research on this theme because, as we already said, we don't have a settlement mindset here. So litigation, going to trials, it's the way here.
Yeah.
Unfortunately.
And the point about Amanda is telling you
Yeah.
is that judicial, the lawsuit, we had like the time is, I don't know, at least I was seeing like a research, the medium time to get the end, the first part of the process is 2 years. And then 5 years to the we call here execution, I think in English, which is the part of the process that after finish the process, okay, you won, so you can start to go to get the money. The median time is 5 years, so at least you spend median 5-6 years. So most part of the settlement would be really better in the beginning of the before the lawsuit. But sometimes we have one thing good about the judicial process, that which is like each month someone can help me with that. We have like 1% of, how can I say juros in English?
Juries?
Interest.
Yes.
It's interest.
1% of the
Interest, right.
every month going. So it's a good investment thing if you want to let your money for, but it's not worth about the money, the time, sorry.
Yeah, well, and given the long time for plaintiffs to recover, that may be in their interest to try and resolve it sooner. Of course, from the defendant's perspective, that may be a good reason to delay and to wait the process out. Now, of course, they may be charged interest, and depending on what they would, I mean, their calculation, whether it's worth it to them to pay the interest rather than use the money for whatever else they would do in the meantime. So it's that kind of calculation that they need to make. But and in the United States, there are some defendants that make that same calculation, that even if they're going to lose, it's worth dragging it out, and part of making it last longer, and sometimes that's intended to discourage the plaintiffs, because the plaintiffs don't have the patience, they may not be able to afford to wait. So it's an unfortunate situation. I guess the real potential for settlement is if both parties have an interest in getting this resolved sooner. If one party has an interest in delaying it, then you're having a hard time. It's less likely to be able to reach an agreement. I'm going to move on. So this may not be relevant, although part of what you can do is ask the clients if they want a realistic assessment. In the United States, if you can tell them that they're, that in most cases where people go to trial, one party gets a worse result than in settlement, do they want to risk losing based on an unrealistic assessment? Most clients will say, yeah, they want a realistic assessment if you ask it that way. And you can tell them you can be confident about some issues and less certain about others. And you can talk about those and discuss the issues you might lose and how you might rebut the arguments, and also the risk the risk of losing and what the consequence for the clients would be. And based on this, you'd be providing a realistic range of probabilities that the court would find in their favor on certain issues. So, you can say, if we're 100% certain that we're going to win on everything, we might get 100,000, but there's some risk that the court might rule against us on certain issues, and therefore the outcome might be less than that. And that's really what this is about, is talking about, or one aspect of this is to talk about trial risks. And so some ways of doing that, you could say, in trial, many judges would have questions about this. So that's identifying the risks. You can quantify the risks. I think that the odds are 2 to 1 that the judge would decide this way about issue X, or you could predict the outcome. I think most judges would decide Y about issue X. So there are a variety of ways of identifying and discussing the trial risks with clients. And of course, how are you going to know this? That's a very hard thing. And I'll talk about that shortly. One of the things that you can do is you can ask clients how you can be helpful. They may want your candid assessment of the likely court outcome. They may want an understanding of the other side's views. They may want advice about litigation or negotiation strategy. And the bottom line here is not to assume. Now, again, in the culture of litigation in Brazil, they may not be thinking about litigation or a negotiation strategy, and this would be something that you would need to raise with them and see if they would be interested in. But I guess the question again always is to not make assumptions and to ask the clients what it is that they really want. So how do you estimate the value of the court outcome? So part of it is experience with similar cases, noting similarities and differences. Once you're in practice for a while, you'll have experience that you can use as a basis for making judgments like this. Do factual investigation, legal research about similar cases, consult with other lawyers or experts, use decision trees. You may or may not be familiar with decision trees. I see some of you nodding your head. Basically, these are ways of identifying particular contingencies of issues about the facts of the law, and you assign probabilities and potential outcomes based on those contingencies or uncertainties, and you combine them and to come up with some estimate of the likely court outcome. again, you're using your estimates, your experience to come up with these estimates, and you may need to vary the estimates since these are just estimates. There's also increasingly in the United States, big data and artificial intelligence tools, lots of databases, or there are some databases and some artificial intelligence tools. I just saw an article recently that relatively few lawyers and law firms use that these days, but my guess is in the future, these are going to become more sophisticated and more economical, and at least for larger disputes and larger companies and larger firms, they may be available. But for the most part, people are going to be using, the experience with similar cases, factual research, legal research, factual investigation, legal research, consulting with other lawyers. And the choice of method depends on lots of factors, including how much is at stake, your experience, the client preferences. Obviously, if there's not a lot at stake, then you're not going to invest a lot of your time and money into this assessment. And if there's more at stake, then it makes it more wiser to spend more time in doing this assessment. So we've developed a framework basically using the logic of decision trees to estimate the mathematical value of the BATNA, the expected court outcome, combines the process into a few steps, systematically identifies substantial risks of adverse conclusions about legal and factual issues, estimates the likely outcomes of various issues, explicitly includes tangible and intangible costs to generate a bottom line for settlement, and you can use different assumptions to develop a range of likely court outcomes. So here's how it works. There are two steps. The first one is to estimate the BATNA value. So you want to estimate the risk regarding liability, and you come up with some percentage, maybe say 80% or 50% or some percentage of the chance that you would win on liability or that the plaintiff would win. Second step is estimating the damages if the plaintiff would win. And then the third step is calculating the BATNA value by multiplying the percentage by the damages. So let's just say you figure that the probability of winning is 60% and the damages would be likely 100,000. So that you calculate the BATNA value, the expected outcome, 60% times 100,000 would be an estimate of 60,000. So that would be your basic estimate about what would be the likely outcome if you went to court. The second stage is to calculate the bottom line. So you want to estimate the tangible and intangible costs, and you can come up with whatever the out-of-pocket costs, the tangible costs for legal fees, for expenses, for experts, discovery, putting a value on the intangible costs, and then calculate the bottom line. So if you said from step 3 that the expected outcome would be $60,000 for a plaintiff, and you say the tangible costs, you work with the client and come up with a value for the intangible and tangible costs of $10,000, the bottom line would be $50,000, deducting the $10,000 from the $60,000. So the bottom line is really important because there are tripwires in negotiation if the parties can't reach an acceptable agreement. Basically, the idea is you want to say, what's, from the plaintiff's perspective, what's the least amount that you'd be willing to take in settlement to avoid going to trial? And so if you're estimating that it's $60,000, likely if you go to trial and it would cost $10,000 in tangible and intangible costs, then their bottom line would be $50,000. If they could get a settlement offer above $60,000 or $50,000, if they could get $60,000 or more, then it would be worth it to them to settle rather than going to trial and taking the risk of going to trial. So the bottom line is a tripwire. It sets the point where you're going to say, no, it's worth it for me to keep on going to trial. Now, obviously, this is a reflection of the culture of making these decisions. It sounds as if there are a lot of other factors in Brazil that people are less likely to consider it in this analytical way. But if they are willing to do it, that's the value of the bottom line, is to help them make that decision as to when it's worth settling and when it's worth going to trial. Now, one of the things, again, I'm not sure the negotiation styles that are used in the United States anyway. It's very common to have a kind of counteroffer process where the plaintiff will ask for a very large amount and the defendant will offer a very small amount, and then they'll have exchange of offers back and forth, and the plaintiff will reduce, will make a series of concessions reducing the amounts of the demands, and the defendant will make a series of concessions increasing the amount of the offers, and the idea is to come up with some amount in between. And the bottom line is relevant there because the goal is to end up with some value that's more favorable than the bottom line. So if you're representing a plaintiff and the bottom line is 50,000, you want to start high enough and make small enough concessions so that you figure you will end up getting more than 50,000, or conversely for the defendant, you want to start low enough and make small enough increases so that you will end up paying no more than your bottom line. So that's why the bottom line is important. It's important as a tripwire to end negotiation. And if you're going to use this counteroffer process, it's a factor that you're going to use to identify what your initial offer is and what your concessions are going to be as you go along. Lawyers are also dispute system designers. They orchestrate the preparation and exchange of information. And this process provides more and better tools to plan for optimal decision-making, accommodate parties' process needs by asking them what their intangible interests are, to think about the timing and the sequence of the process, and to consider using mediation or other dispute resolution processes when appropriate. Now, I gather you don't have a lot of mediation in Brazil, and so that may not be an option. I'm not sure, for example, if arbitration is an option very frequently. It is, I gather. So part of what this is about is having and you were referring to it earlier, basically being a dispute system designer to try and think about how you wanted to plan the process to come up with a result and a process that's going to satisfy your client's interests as well as possible. Again, if you don't have mediation there very much, this may not be very relevant. Sometimes I'm assuming that folks know what mediation is, but go ahead.
We do have here, yeah.
You do have
We
some.
do have, yeah.
The number of mediation
actually.
increases.
Yeah.
Yes,
It's much calmer than negotiation.
Okay, well, that is good to know. Well, then, thank you.
Okay.
Just to clarify, here in Brazil, we have on the special courts that Jose has mentioned, and also in our courts, we have something that it's like an evaluative mediation here, but for us, it's like conciliation, that it has greater views than mediation, but we're getting bigger here. Okay.
Well, obviously then, thank you for clarifying that, since mediation is an option, and you're aware of that. So one of the things that you can do is consider if having a neutral third party can help. In the United States, most cases are settled in direct negotiation between the parties or the lawyers without a mediator. And the lawyers will often bring in a mediator if they can't reach a negotiation by themselves. If the animosity between the parties is so intense, or their assessments and their expectations are so extreme and unrealistic, they may need the help of a mediator to resolve some of their unrealistic expectations, help them become more realistic, help them deal with some of the emotional issues and the conflict. So mediation can be helpful when the parties can't and the lawyers can't negotiate well between themselves. Mediation can be very helpful because the mediator organizes the process systematically. It provides a settlement to focus on negotiation. One of the things that happens is that if you don't have a settlement event, people are just busy doing other things and they're not going to really focus on negotiation. So mediation is a time where people devote their time and attention to trying to reach a settlement, and that in and of itself can be helpful. It provides some independent help in doing litigation interest and risk assessment, can avoid problems of reactive devaluation where parties reject ideas just because the other side suggests the ideas. So if you have a mediator suggesting the idea, parties may be more open to hearing it from the mediator than from the other side. And that's a way to get around this reactive devaluation that we talked about earlier. I've been encouraging people to use what we're calling planned early two-stage mediation. I wish people were using it more often. I don't think that it's used that often. I'm going to mention it briefly. It makes perfect logical sense, but people often don't do it. In the United States, for civil mediations, basically for contract disputes, for tort disputes, things like that, other than family disputes, there's an expectation that mediation is going to be done in a single session, in a single day. And that can be helpful, but it also can undermine good decision making. Can put a lot of pressure on parties to settle before they're ready. And we have what I call marathon mediations, mediations that start in the morning and people stick around past dinner time, sometimes late into the night, to try and get cases settled. And it undermines people's decision-making ability, and it puts great pressure on them to settle. And it can result in buyer's remorse. They can reach an agreement and then the next day decide that it was a bad agreement and they want to renege on the agreement. They may not perform it well. It may prompt complaints against mediators if you have these marathon mediations. And so my co-authors and I suggest this process of a two-stage mediation so parties can consider these LIRA issues after the first session. So what you would do is have a first session, talk about the issues, identify any information or consultations or whatever parties need before they can reach an agreement. So if they don't, I mean, they can settle in one session if they can, but if they do settle in one session, they don't need a second session. But if they don't settle in the first session, they can do their homework to prepare for the second session, which gives them time to get more information, to consult others, and to reflect on their mediation goals and strategy. Now, we've also suggested these planned multi-stage mediations, and this is where one can take advantage of the virtual mediation process to break mediation into multiple stages during a particular period. One of the things that happens, at least in the mediations here in the United States, particularly in these civil cases, the non-family cases, much of it, maybe most or all of it, the parties don't meet directly with each other. The mediator shuttles back and forth from one side to the other. I gather that's pretty common and in Brazil. And so what that means is that the mediator may spend an hour with one side and an hour with the other side. So there's a lot of dead time where it isn't very productive. The parties are, get cranky and impatient, and it's not a very productive process. It could be a lot more productive to schedule in advance a time where the mediator would meet by Zoom with one side and then another time with the other side, and you can just schedule the process. The mediator could plan with the lawyers, what the schedule would be so that you use the time efficiently. And you maybe, instead of trying to get it all done in a single day, you might be able to plan to get it done in a week or less or more, but in a particular period of time. And since the parties and lawyers aren't traveling, they don't have to be together all at the same time. Mediators can schedule caucuses with just one side without the other side waiting. And one of the big problems that we have in the United States is that, where you have mediations face to face, mediators are often frustrated because, and parties are frustrated because the authoritative decision makers in business disputes often don't want to attend. You're not going to have senior executives coming to a mediation and just spend all the time to travel and all the time without necessarily making the decision. So it's frustrating because the people who are there aren't able to make decisions. With these virtual mediations, you can just have these authoritative decision makers get involved just for the periods of time where it'd be most useful, which may be particularly at the end of a case, and also maybe at the beginning of the case, just to learn about it. So the book includes lots of helpful appendices, including an interview guide for lawyers, discussing litigation interests and risks with family law clients where the dynamics are somewhat different, improving estimates of expected values of court outcomes, a quick primer on decision trees, an example of a decision tree, and advice about self-care by practitioners. So that's a quick summary. I don't know how quick, but that's a summary of what the ideas in this book about litigation interest and risk assessment, which to some extent may be helpful in your context. Obviously, as we've been discussing throughout, you have to apply it in your context, and some of the things that we've talked about may not apply, but some of them may, or some may apply for some cases with some parties where, particularly if there are some intangible interests that they are really concerned about and they want to address in the litigation, and maybe don't want to wait for 5 years before they get this case settled. So that's the end of my presentation. Let me see if people have questions or comments. I'm gonna stop the share here.
First of all, we wanted to thank you for this really good presentation that we have here. Really true, I love it. Was really useful for me at least. But I have a question that you have a talk about the decision tree. I was studying about this, and so you can use just to define your BATNA value is just for that. So your method, the LIRA is way the perspective is bigger than just the decision tree. Is that correct?
Exactly right. Thank you for mentioning that. And it's really primarily about developing the expectation about what the outcome would be in court. I've seen some decision trees that also take into account, I mean, you can take into account the litigation costs, the tangible costs. Sometimes people don't do that, but you really can't take into account very well the intangible costs. And people sometimes take the outcome of the decision tree or the expected court value, and they use that as the bottom line. But that's a problem because it ignores the intangible costs, which, as I say, can be so important for parties. So I've written some blog posts that don't make me popular with some of my colleagues back here in the United States, saying you shouldn't be focusing so much on the BATNA because that's only part of the calculation. You really need to be thinking about the bottom line, which, in addition to considering the expected value of what would happen if you went to court, the tangible costs, that is the legal fees or other out-of-pocket costs, and particularly the intangible costs. And I guess if there's one thing I want to leave you with, is to encourage you to talk with your clients about these intangible costs, what the process is like, what they really care about, how this would affect their lives. Now, some of them, this may not be a concern for them. They may not want to focus on that. They're really just concerned about what the outcome in court is. That's what their expectation is. But if you have a good conversation with them, if you listen well, if you ask them what's important to them, you may be able to help them more by solving their conflicts and by developing better strategies. Now, there's a risk to this, which is that if you help them develop a bottom line that incorporates their intangible costs, and the other side isn't focusing on that, it may disadvantage your client in a sense that they may be having too low expectations. On the other hand, it may be, even if that's the case, even if the other side is taking a very tough position, if your client really can't tolerate litigation and continuing litigation is a real problem for them, even if they get a worse result in terms of the value of the settlement itself, the overall value to them may be a lot greater. And let me just give you a brief example. I interviewed a lawyer who's telling you about a case where his client was just found that the litigation process was just intolerable. The other side was just being so hostile and mean and abusive that his client could not stand being in the litigation for very long. And so his client received a less favorable settlement than the client would have if he could have tolerated the abusive process in the litigation. Well, on the one hand, the client is getting a less favorable outcome. On the other hand, I mean, in terms of the actual dollar value that the client received, on the other hand, the client was getting a great value in being relieved of not having to survive and live through that litigation process. So part of it is helping the client identify what their value, what's important to them. And that's how the developing of the bottom line is really the key thing. So anyway, I'm going on at length, but your point is exactly right. You should be focusing on the bottom line and not just the expected court outcome.
The question is how much your freedom is worth it. You know, sometimes you get into a litigation process, but perfect for me. Thank you very much. I just want to clarify one more thing that Larissa already told you about the mediation culture here in Brazil. In the past few years, the mediation culture is increasing a lot, but
Right.
yes, we have mediation for a family case. The competition that I already said to you, the Brazilian national competition, happened last weekend. We had, like, I don't know, maybe 30 teams from our part of Brazil. So we are increasing this culture. We don't want to say just, oh, we are here, just litigation. No, not the point, but the most part of the lawyers who has 40 years old, 45, 50, still think that's the biggest point. But John, amazing. Thank you very much. Thank you for sharing your knowledge with us. It was really good. And I don't know if someone wants to say one more thing for you. Please.
Yeah, I know we're running a little past time, although I'm happy to answer any more questions or continue in the conversation. Does anybody have any more questions or comments?
I think it's really nice too to have this conversation with clients, because most of the lawyers don't even know what the clients want, and actually the clients doesn't know what they want. So it's really nice for us to have and understand what they really want, what is the matter, and what can we do with it, so then we can have better results with it.
I'm really glad you mentioned that, Amanda. One of the things that clients don't, they come in, they are confused, they're upset, they don't understand the law, the process. And so one of the great values that lawyers can provide is helping the clients understand what their conflict is about. And the clients may think they understand when they come in, but they often don't, in part because of the biases, in part because of the emotions. And so doing exactly what you said is really what I think good lawyering is about, is helping the client understand and then really developing a good understanding, a mutual understanding between the lawyer and the client as to what the problem is, and then developing a strategy for the best way to try and resolve it.
Yes, absolutely. So then we can know what is the best way to do it. Is it trial, mediation, negotiation, arbitration? What is the best solution for your client for this specific problem that he needs to solve it?
Absolutely. Other comments or questions?
Someone to Pedro, Ana, Lorenzo, Rodrigo, Diego, anyone to say something?
Going once, twice.
Yeah,
All right. Well, thank you so much. I really appreciate the opportunity to talk with you and share my experience. I hope this has been helpful for you. And I wish you all good luck. You know, I'm a retired. I didn't say much about myself. I retired from teaching a couple of years ago. I'm still involved in a variety of activities, and but I'm at the end. You all are at the beginning, and I wish you all great success in your careers, whatever you end up doing.
thank you
Thank
very
you so much, John.
Thank you,
Thank you
John.
very
for
much
speaking.
for your time.
All right,
Thank
bye,
you for
everybody.
Hey, Amanda, you wanna let's take a picture of the
Yeah.
with wait,
Sure.
let's put in the